today is an introduction to the court system. And we'll talk a little bit about the federal and the state court system, and then we'll talk about legal procedure and court procedure in our next class, along with many other topics. Okay? So if I didn't even put anything else on the slide, and I just asked you, as non-lawyers, what is the law? Could someone tell me, in their own words, what they think the law is?
Rules of conduct.
Yeah, that's one way of, sure. Anyone else? And you sort of learn about like different perspectives that people come from. Shout something out. Yeah, it is rules of conduct prescribed by some outside entity, usually, right? It's one way of looking at it is somebody telling you how to behave, right? And when you say you, that's one of the big things we have to sort of start thinking about when we take a course in business law. Most of us, when we think about you, think about an individual, right? Us, a living, breathing person. True. But think about also as the law applying to a corporation, a business, right? So there are lots of things that a court, a governmental entity, a regulatory body, an agency will tell a business to do or not do as well, right? So yes, we're going to talk about the law applying and prescribing rules of conduct, not just to individuals, but to entities and corporations and businesses as well. So that's a way of sort of shifting our thinking. And we'll see when we talk about the Constitution of how a lot of the freedoms that we think about as applying just to us, an individual having the freedom of speech, well, a corporation may want the freedom of speech as well for various reasons. So think about it a lot more broadly. Okay. So what is the law? Yeah, it's a bunch of rules that regulate conduct of, again, individuals, businesses, and other organizations in society. Why? Right? And if I sort of phrase the question a different way and said, why do we even have the law? Shouldn't we just be free spirits, allowed to sort of roam about and do our own thing? Well, sure, that would be nice, and it's hopefully we can still do some of that, but really, over time we realize that to live in an organized society, you need to have a set of minimum rules of conduct. Why? Because you need to protect individuals and entities and their property from unintended or unwanted interference from others. That's a nice way of saying, for potentially criminal behavior, right? You need to sort of have checks within society, and how else would you do it except for having laws that sort of protect and help do that. And you're going to have to tell people and even entities what it is and what it isn't that they can do. So not allowing people to engage in quote-unquote undesirable activities. And what do we mean by that? What does the law tell us that we can't do? I mean, we do it, but there will be consequences to that. A trick question.
It happens a lot with tax.
Right, tax evasion. Yeah, I'm glad that you're thinking of it. Usually the answer is you can't kill someone or you can't steal. Well, there's that, but tax evasion. Why? Because everyone should, again, if there's a tax code on the books, yes, it is, you could work within the legal parameters of that, but you should, right, and you shouldn't discriminate against people in employment, or you should abide by certain minimal environmental standards. And again, I'm thinking more, the law applying to businesses. Right, this is a course in business law. So yeah, I mean, it's forbidding individuals from engaging in certain activities that would be harmful, overall harmful to others, and there are then sanctions or consequences to those individuals or businesses that violate the law. And some of those consequences are not just we're going to throw people in jail, but those consequences could be fines. Those consequences could be shutting down the business, lawsuits or things like that. So there are monetary consequences to undesirable behavior. And here's another one. How do you define the law? I mean, after however many years of doing this, I don't think any one person is going to have a definition of what is the law, but there are various ways of looking at it. And again, this kind of gets redundant. Yeah, it's a bunch of rules that are, as I said, prescribed by some controlling authority. And what do I mean by that? I typically mean the government, right? Whether it's at the federal level or at the state level, or it's acting out through one of its branches, or it's through one of its administrative agencies, or whatever the case might be. But it is some recognized legal body of authority that has the power to enforce a particular law, right? And as a result, that law has to be obeyed and followed by citizens. Otherwise, there are, again, consequences to that, which could be criminal or what we refer to as civil consequences. And we'll talk a lot about the difference between criminal versus civil, because when we're talking about civil consequences, we're often talking about, not exclusively, but often talking about monetary damages. Why have the law? Well, obvious. We've talked about a lot of these reasons already, and you certainly don't have to memorize a lot of this, but here are some reasons. And none of this should be shocking to any one of us. But yeah, keeping the peace, having an orderly society, shaping moral standards. So this one is kind of touchy-feely. Shaping moral standards. Wait a minute. Is it the law's job to shape moral standards? And besides, my definition of morality would be very different from anyone else's definition of morality. So the law really has to be quite careful in this respect. I mean, there is some behavior that I think is universally accepted as being immoral. Thou shalt not go out and kill, right? Or steal, yes. But beyond that, and what I try to do in when I'm teaching these topics that are have been taught in business law classes for decades, is you try to bring in current events, stuff that's happening today. So we're not talking about things that happened ages ago. And by the way, one of the things I sort of highlight in the syllabus is read. I'm sure you do, but read current events, read good. Get good information, and I know most of us get our information very quickly, on our smartphones or whatever. But when you can, read a good newspaper. Read the Times, read the Journal, read the Economist or whatever. Keep up with some of these, events, and you'll see how a lot of it just kind of melts into exactly what we're talking about in class. And when I talk about moral standards, what's been in the news lately a lot in the news cycle is Kentucky. Right, where we have a county clerk who is refusing to issue marriage licenses to same-sex couples based on a very controversial Supreme Court decision handed down just this summer, right? So here we are today in 2015 struggling with what is the law's role and how to sort of moral standards which differ from individual to individual, but they impact whole communities. How do we deal with that, right? So, again, when I said that reasonable minds will differ on this, and there will not be black or white answers, and there will be a lot of gray areas, and there will be, it's a kind of topic that I'm thinking about assigning as one of our, discussion points for a course assignment. These are the hot topics that kind of, sort of bring into what is the law's role in society? And how do we deal with this sort of thing? So again, yes, the moral standards are part of it, but these are very, very complicated issues. All right, real quickly, promoting social justice, of course, right? I mean, the idea that we have a Bill of Rights, the idea that, the U.S. Constitution and the law is designed to be fair to everyone. And, again, pick up current events and, we could have a debate about, have we reached the pinnacle of social justice? Probably not. It's a work in progress. But do our laws facilitate? Do our laws continue to promote social justice through various types of anti-discrimination laws and so on? Maintaining the status quo. I mean, that's really important when you think about businesses, right? Having an orderly system. having orderly change, maintaining the status quo, being able to facilitate planning. You know, one of the things that businesses want most is certainty, right? You see that when the stock market is tanking or when there is some, upcoming election or whatever, businesses just stop because they have no idea what's going to happen next, and they're going to, kind of develop their strategy around, once they know that things are settled. So, the legal system, by working in a way that is predictable and according to the way it's supposed to go, is really kind of helping when individuals and businesses sort of do their thing, right? Because the law and every other facet of the economy are kind of linked together. So the function of the law is to kind of work within it, not to act as a hindrance toward it. Provide a basis for compromise. Well, yeah, I mean, as we just said, people will disagree. And if they disagree, do we want them to, do we want to have like an old West style shootout or something? No, we want to resolve these issues in a civilized manner, if you will. And for that, we have a court system, right? Where there are, as we'll see, several levels of appeals and so on and so forth. But in the end, we have to figure out a way that even if we don't agree with a particular decision, once it becomes, quote unquote, the law, that we have to, as elected officials or as business people, whatever, abide by it. So the law figures out a way to kind of help us get to a compromise, and again, maximize individual freedom. Not give us individual freedoms 100%, because again, that could lead to, everyone sort of doing their own thing and having a vigilante sort of society. But how is it that we could maintain all of these other things and still have individuals and entities have the maximum freedoms that they possibly could? I mean, that's sort of the goal and functions of the law. And we can have a debate about whether we do this perfectly or whether we come close to doing it as best as we can, right? I mean, it's one of those things that, we, as a society, as a legal system, strive to do. Okay, so qualities of the law. Well, I mean, not to toot our own horn, but we'd like to think that the U.S. legal system is comprehensive, which means it basically covers all bases, is fair. I didn't say perfect, I said it's fair and democratic, right? I mean, yes, that's what we hold dear, and that's what we strive for. And what I find even more fascinating is that the U.S. legal system is intended to be flexible, right? Flexible in the sense that, we're still relying on the Constitution, a document that goes back centuries at a very, very different time in history, to be the document that guides us today. Today, in 2015, when the world looks a whole lot different than it did 300 years ago. Well, how can that document and set of laws over the years be current to keep up with changing times? Well, the law has to evolve. It has to. And I would dare say that it has. Not perfectly, but it has done its part to keep up with changes in how society is, right? Norms of society, how our thinking has evolved, how technology has evolved. I mean, think about it. You go from being a rural agrarian society to going through the Industrial Revolution, to going through a manufacturing world, to going through a very technologically driven world, to God knows what's next, right? To be able to have a legal system that keeps pace with all of this, really speaks to the flexibility of the legal system. And the last bullet here is talking about the U.S. Supreme Court decision in Brown versus Board of Education as an example of the flexibility of the law. And we'll talk a little bit more about this decision. There's another slide coming up, but I assume people are familiar with that decision. Okay, so every chapter has a couple of cases, 2, 3, 4 cases. And I know it's a first class, but let me just sort of tell you what I like to do with these cases. They're not, by the way, these are not the entire case. This is basically just a little summary of the case, where the textbook editors have basically read the court decision, have summarized the facts, have summarized the issue, and it's giving you just like a paragraph of the decision, but it gives you a flavor for what happened, and it ties in directly to what we're talking about. So, talking about the moral theory of law and ethics is this case of Palm. Anyone sort of been to the grocery store and sort of seen, the various drink aisle? Has anyone seen a bottle of Palm? Right? It's a drink, along with all other kinds of drinks. So Palm Wonderful sued the Coca-Cola, big, huge Coca-Cola company, and the case went all the way up to the Supreme Court of the United States. And the issue in the case was, can a private party, right? These are both private companies, bring an unfair competition lawsuit under a federal law called Lanham Act against a competitor that challenges the truthfulness of a food label? I don't know. Well, the only way we would know this is if you read the case, what was in the textbook. Did anyone? And again, I don't need like everything. I just need a little snippet of what was going on here. Yeah.
Palm's juice was 97, something like 85% pomegranate and 50% blueberry. With Coca-Cola's, we were advertising that it was pomegranate and blueberry, but they only had like 3% and 7%, like 0.3 and 0.2, and then the other one was aggregates and flavoring. So that was.
So, I'm just going to play the devil's advocate.
Mm-hmm.
So you've got two companies that are selling their products, and we're the consumers. We buy what we want, and I'm looking at the Palm bottle, and I'm looking at the Coca-Cola version, and I'm looking at both of these things look like fruity drinks, and whatever. Sometimes I read labels, sometimes I don't read labels, and I put one into. What's the problem? I'm just playing the devil's advocate. Why is Palm going after Coca-Cola company? Just because my drink has more fruit juice versus yours, why does that give me the right to sue the Coca-Cola company?
I think it was because of the, I just read it today because I got a book yesterday.
But anyone else, why, and thank you, that's a perfect synopsis of the case, and I'm just sort of, teasing you with that. Well, the problem is that, look, we're all susceptible to marketing, and Palm's point here is that, look, we actually are a company that are putting in really good stuff into our drink. We're not using additives. We're actually, pomegranate is a really healthy fruit. We're using 85% of that, and 15% blueberry. Do the math, it's 100% good stuff. And here's a soft drink company that, through its slick advertising, has got this huge piece of pomegranate on its label and this big piece of blueberry, and down below, in like 2-point font, it basically tells the story of, it's other ingredients too, and it's basically derived from whatever. So if someone really bothered to read all of that, and someone like me would need her reading glasses to see all of that, if I just saw that healthy looking bottle, I would say, yay, I'll take that one, So they're basically saying that, look, this is not truthful. And it's hurting us in our business because we're actually trying to put out a better product, and there's someone else that's taking our glory and putting out an inferior product. Look, we're not telling people what to consume. If people want to not have the healthy stuff, it's fine, but don't let Coca-Cola get away with arguing that they're doing the healthy stuff when they're not. And Coca-Cola's defense was, wait a minute, the Food and Drug Administration, the FDA, has looked at our labeling and approved it. We're not doing anything illegal, This is, all is fair in, business, so lay off. So the question that kind of went through the courts was, can these two competitors can one competitor sue the other when the issue is not so much the lawfulness of the labeling, but whether or not it is deceptive, whether or not it's unfair competition. And the Supreme Court said, yes, the case can go forward. So, basically the case in the book is not telling you how it all turned out. It's basically saying that Palm has what's called a cause of action, meaning it can proceed in court against Coca-Cola, and Coca-Cola's defense was, well, the FDA didn't stop us, is not enough. Doing this could possibly lead a judge or a jury to decide that, yeah, it is unfair competition for you to have this huge pieces of fruit there and basically have 2% or 3% actual fruit juice in there. Okay? So again, it's a case that sort of comes up with law versus ethics, right? And morality doesn't have to be personal morality. Morality can be business ethics as well, and that's what this case was about. Okay, good news. The next few slides and the business in the book about all these various schools of legal thought and philosophy are something we don't have to memorize. Yay. Because, the idea of sort of going through this is not to say, well, do you understand what the historical school says? Or do you understand, what the analytical school of thought is? No, the point here is that, look, the US legal system or any country's legal system didn't just come about one day because someone sat down and started writing, the law of the land or the Constitution one way or the other. It was shaped by a history, by a philosophy, by whatever that group of people together believed should shape their legal system. And that came from a variety of different sources, right? And those sources could be things like, well, again, this is for those of you, anyone taking a philosophy course, and do people take philosophy courses anymore? They don't. No luxury of liberal arts anymore, I guess. But anyway, philosophy, basically you could look at it a different way. You could say, well, gee, should we base the law based on, what some outside source tells us is the right thing? And it could be whatever, right? Most often it could be based on, a religious text, for example. What is right, what is not right? That normally would be what the natural school of law would look to, right? And I would argue that we do a little bit of that, but that's not our legal system in the sense that there is very much a separation of, secular versus non-secular beliefs, but that's, again, a way in which the legal system could be derived. Do we base it on a set of social traditions, our social traditions as a society? Sure, I think it's partly that, and on and on. And law comes about from logic, what works, what doesn't work. If you fine corporations for dumping waste into the oceans, well, they'll stop doing, if it hurts enough economically. So yeah, there's that sort of reasoning that comes into it. And on and on and on. The purpose of the law is to advance certain goals. It's to advance, freedoms for everyone. Sure, that's probably part of, the thinking of our legal system. Law is a set of rules developed and communicated by a ruling party. The law changes when the ruling class changes. No, this looks a little bit less democratic. I don't think we derive too much from this school of thought, but I can, assure you that there are other places in the world where, it is more of a monarchy or more of a, select group of people that are sort of looking over a society versus a democratically elected kind of, government. So, again, there are all kinds of ways in which a legal system could be derived, and we could go on and on. The last one being very simple. Let the market decide, right? Let most decisions be made based on, sort of this very, very sort of Chicago school of economics kind of way. And, I'm sure we have people here, I'm sure we have people in our society that feel that we should have more of a capitalistic system, that government should not have so much regulation. We should, be more free market oriented and so on. So that's always a pull. It feels like we're already in the middle of an presidential election cycle, doesn't it? It's only 2015, actually. The election is obviously next year. But we're starting to see some of this rhetoric, aren't we, from one side or the other. So yeah, a lot of this sort of way of thinking affects what our legal system is and what our legal system becomes, and what our legal system sort of, in a pendulum goes back and forth over. So the point here is that, yeah, these are sort of the philosophies that shape, legal systems in general, and including our own, right? So this is sort of more of a history lesson kind of a chapter anyway. And that brings me to the next point, which is, well, how did American law come about, right? We're not as old a country or a nation as some of the other nations are, right? Obviously. The U.S. has managed to do quite well, over a very short period, but it's a relatively new nation. And it shouldn't surprise us that the American legal system, excuse me, is derived from what else but the English system of law. Why should that be? Why did we pick them as opposed to anyone else? Well, we don't have to look far into the history to say, well, who were the original pilgrims? Where did they come from? I mean, who did we fight the Revolutionary War against? Wait, okay. So, I mean, it's not shocking that the U.S. legal system is based on, I'm not saying that if you look at the British legal system that it's going to be exactly the same today, it's not, but that is really the foundation for the U.S. legal system. But then it went in its own direction and really did come up with a very unique way of governing. So yes, the foundation is based on a system in which, and read these words carefully, American judges developed common law in America. Common law. And I sort of joke a lot when we sort of start learning terminology that you sort of say a phrase, common law, right? Common law. Those are just words, right? But words that kind of are just words in the English language start to have legal meaning. Because if you're, once you sort of go through this course and get more familiar with legal terminology, you'll see that when I say common law, you'll say, aha, she's talking about case law. She's talking about law that has been developed or precedent. We're talking more about, because what happens is the English sort of had the system about, well, once a case is decided, right? You have facts, you have an issue, and you apply the law to it, that holding in a case becomes precedent. And by that I mean other courts will look to it to guide the next decision, right? And that is a unique feature of the American legal system. And when we look to past decisions to guide us in future cases, we are basically talking about a common law system, okay? So maybe something that I kind of didn't say in my introduction is what I find helpful, and after teaching this course for so long in the style that I do, what I encourage students to do is, print out the slides. Bring them with you. Unless you are a fantastic note taker, you're not going to be able to annotate your notes as well as if you had something in front of you and you're writing things down. When I say common law, circle it, whatever, and say what, say in your own words what that means, because these are concepts that I'm going to throw out at you and layer and layer and layer, and there's a lot of information. It would be helpful to you if you had that information in front of you, okay? All right. All right, so what is common law? Well, again, it's developed by judges who issue opinions when they're deciding cases, and the principles announced, whatever the legal principles are in that particular case. And the legal principle goes far beyond who won the case, right? If you think about just the one case that we've talked about so far, the Palm versus Coca-Cola case. Palm kind of won that case, didn't they? Because the court said that they could go ahead and sue Coca-Cola for unfair competition. That's not the legal principle. The legal principle is not that Palm won. The legal principle is that, yes, a private party, two private companies can be in litigation with one another over whether or not one is unfairly competing based on deceptive practices. That's the legal principle, right? It doesn't matter who the individual parties were, because that's the principle that becomes, again, that big word, precedent for later judges in deciding similar cases. And that is a unique feature of the US legal system because we have adopted that way of, that way of sort of deciding future cases based on the English common law. And this is, again, a little bit more history than we need to sort of worry about. It used to be that the English courts were divided into like 3 different courts, and they were referred to as law courts, equity courts, and merchant courts. Okay? That's not how we do things here. We'll see when we get into our legal system, we don't have law courts or equity courts or merchant courts. But this is sort of historical, because if you wanted, but it was sort of this notion, well, how do we set up a court system? Well, if I want to sue somebody and I want damages, I want monetary damages, I go to one kind of court. But if monetary damages are not going to do it, if I want something else, if I want to get an injunction against someone, if I want someone to stop doing something, if I want Coke to pull that labeling, right, I have to go to a different court. I have to go to an equity court that has the power to stop a private party from, marketing in a specific way. Oh, and by the way, if my dispute is a commercial dispute, then I have to go to a different kind of court. I'm not sure where the British legal system is. They may still have some tenets of this. We backed away from all of this. In our system of case law, you can sue a party and ask for monetary damages and equitable damages in the same lawsuit. You don't have to go to different courts, right? But it sort of got us thinking about we do need a way to set up a court system, and we'll talk more about that. So we didn't kind of take this wholesale from the British. And then what we did, I'm taking credit for something that happened more than 300 years ago, was the U.S. legal system is based on a fabulous, not very long document that was finally adopted, and of course we know that is the Constitution, and it sort of pained me to see that they did not include the Constitution as an appendix to the textbook. I used to be able to tell people, well, if you have insomnia, if you have trouble sleeping, if you're bored on a Saturday evening and no other plans, pick up Appendix A of the textbook and read the Constitution. It's thrilling. It really is. It's a short read, but again, just because it's not in the textbook doesn't mean that you can't Google it and just sit there and kind of get a flavor. Has anyone done that? Ever? It's been a long time for me since high school and stuff, but to me it's almost like, why not just look at those few pages and kind of just see how a document that is set up, with 3 branches of government, with separating out their powers, with talking about treaties, things that are just totally relevant today, because again, it's a document of few words. It's broad principles, right? So you could have a document written in the 1700s that absolutely could govern today, and in fact is governing today. So anyway, that's just my plea to people to sort of, not be afraid of looking at the various articles in the Constitution. So really, what are we talking about? We're talking about the Constitution, federal law, being sort of the supreme law of the land, meaning that, we'll talk a lot about, when we talk about constitutional law, I think next class, about there being a federal system and state system and state laws and even local laws, but quite frankly, any law that conflicts with the Constitution or federal law is unconstitutional. A lot of cases go up to the Supreme Court because someone will say, well, this law that was just passed even by, Congress is unconstitutional because it violates this part of the Constitution. And, those are the fascinating cases that the Supreme Court often decides. And it sort of brings home the point that the Constitution sits here and everything else is underneath, under it. And that's not to say that, you can't have a law that goes beyond or is different than, but if it conflicts with the supreme law authority, it is unconstitutional, which means that it can be thrown out, right? And that's sort of this notion, as we'll see, that we have 3 branches of government, right? And, I can't point to any other place where this is the case. This is so unique about the US legal system that there is a legislative branch. And what is the legislative branch? You don't have to read the Constitution to know that.
Make the laws.
Right, but who are they? Congress, right? I mean, sometimes the question is so easy that you're afraid to sort of yell out an answer. You know, it's the U.S. House of Representatives, if we're talking at the federal level, and the Senate, right? That's the legislative branch, and all the agencies underneath it, and all the drama that goes with it. There it is, the legislative branch. The executive branch, obviously, that is the president, but it's more than that, right? It's the cabinet, it's the executive agencies, and so on and so forth. And the judicial branch. And the judicial branch is more than just at the federal level, the Supreme Court, as we'll see in the next chapter. It's all of those other federal courts at the, district court level, appellate level, all the way. So we're talking about 3 distinct, huge bodies. I talked about controlling authorities. Well, here we go. We're starting to see how the government is sort of set up, and that is the federal government. And again, for those of you that are constitutional buffs or constitutional scholars, you know that federal powers, the power of the federal government, comes from the Constitution. And the second bullet is sort of interesting. Powers not given to the federal government, according to the Constitution, are reserved for the states. A lot of people think, well, shouldn't that be the other way around? Shouldn't the federal government have a whole lot of powers, and whatever they think the states should have, the federal government should give the states those powers? No, the Constitution is sort of interesting in that it goes in the reverse. It says, here are the areas of federal domain, if you will, and everything else is reserved for the states. Why do you think that is? What was the backdrop to the Constitution being adopted? It's been longer for me, for history and social studies, but it's been less for you guys, I would imagine. What was going on? Who were we fighting the Revolutionary War against? Great Britain, right? I mean, that was fighting against King George and this whole notion of there being too much of federal government, too much of a monarchy, right? So the Constitution was written in a way to really balance the powers of federal and state government, right? To not let the federal government get too powerful, to allow the 50 states to have their own sort of autonomy, to keep that balance, and in fact, even within the federal government, not let the executive branch become too powerful, to kind of balance that with the legislative and the judicial branch. And that really is the beauty of this way that this, the U.S. system is supposed to work, in that you kind of do not let any one part become too powerful, that you constantly keep it under balance. That leads to complexity, but that's a unique feature. And we see that states, 50 states and DC, have their own state constitutions and have their own state government structure. So the law is complicated. And by the way, here we are in business law. Businesses have to abide by laws, by regulations, by decisions, from both the federal and state levels, and you can see how there is a whole lot for even a non-lawyer to appreciate in terms of how the legal structure works. Okay, real quickly, the other thing that comes from the Constitution and sort of federal law is the ability of the executive branch of the government to enter into, well, I shouldn't say the executive branch, it's the president, with the advice and consent of 2/3 of the Senate, so you bring in the legislative branch into this as well, to enter into treaties with foreign governments, right? And my God, do we not see this playing out today? What are we talking about today? I mean, these days, we're talking about all kinds of things, including the big deal with Iran, right? Here's the president negotiating. Here's the legislative branch in horror over the whole thing. And here's a whole lot of negotiating that is going on. And even if we don't always appreciate all the procedural part of it, we see that ultimately it is the executive branch that negotiates with foreign governments. yes, the legislature has a say in it, and they can sometimes kill it, they can sometimes help it succeed, but they may not always be on the same page. And many would argue that it's healthy for them not to be on the same page because it leads to debate, it leads to a discourse over these very, very complicated issues, and so on and so forth. But where does it all come from? It comes from the way our legal system is set up. That you that you cannot have, the other thing we're talking a lot about these days is the whole immigration issue coming from the southern borders, and this notion, well, shouldn't the southern states have more of a say in how they patrol their borders and so on? And then you're coming up against sort of this wall about, well, wait a minute, it's not Texas, it's not New Mexico, it's the federal government that has the power under the Constitution to actually negotiate and do something about these issues, and the state governments sort of have to play within the parameters of their authority. So, these are not sort of like, well, this is ancient history. This is stuff that is current and relevant, and these are just two very simple examples of how, again, we're talking about a balance of power. All right, we're going to use the word statute a lot, and oftentimes I'll just say the law, and the law could mean a bunch of different things, but the word statute is really important to understand. So what is a statute? Well, a statute is something that is passed by a legislative body. Okay? So a federal statute is basically, and the only entity that can pass or introduce and pass a statute is Congress at the federal level. And by the way, you can have state statutes as well, right? Here in the state of New Jersey, we have two houses as well. It sort of, it mirrors, the Assembly and the Senate sort of mirror what's happening at the federal government. So we sort of have the same thing. So you could have state statutes or federal statutes, but just, again, sticking to federal law for a minute, written laws that establish certain conduct and so on. The U.S. Congress, and remember, there are two bodies within the U.S. Congress, will enact federal statutes, and they can be for a whole bunch of different things. For example, to regulate foreign and interstate commerce is just one example. And then the statutes go into what are referred to as code books. Yes, we know all that. I mean, it's sort of that's old terminology, but yes, who adopts the, when we talk about a statute, and, one huge example of a law that was adopted not too long ago, but it's still in the news in a big way, is the healthcare law, right? When we talk about legislation that has been big legislation in the past few years, it's the Affordable Care Act, or the healthcare law, that passed through a very, very, very divided Congress, and was ultimately, by the way, every law has to be signed by the president. The president has the ability to veto it. But in this case, President Obama supported it and signed it. But you start to see that is an example of a federal statute, a law that was passed by Congress. But there are a gazillion examples of that. We'll talk in business law about, for example, securities law. And you guys know from all your other courses, when you talk about the Securities Act of 1933, the Securities Exchange Act of 1934, what is that? If not federal statute. It's a law of Congress passed way back when that, again, deals with a specific area that the federal government has the ability to govern on, to pass legislation on. Okay? So statute equals laws passed by Congress, to say it simply. And as we've already talked about, states have their own statute. And remember, state law can exist side by side with federal law as long as it does not conflict with, it doesn't contradict federal law. So we have state legislatures passing state statutes. And by the way, we can even have local governments passing local statutes, which are referred to as ordinances, right? I mean, you could have a city like Newark deciding that they want to have a particular area of economic renovation, and they'll, pass ordinances to help that. So again, statutes can be at all of these different levels of government, but they are ultimately only something that are adopted by a legislative body. Everyone with me? Questions? Hopefully a lot of this is just review. Real quickly, what else can be a source of law? We've talked about Constitution, we've talked about statutes, well, treaties. One other example is an executive order. And we've already talked about the executive branch, and we know who heads up the executive branch. It's the President of the United States, and we know who heads up, for example, a state, it's a governor of a particular state. And to the extent that the president or the governor wants to or needs to do something, usually that is a matter of a pressing nature, that it cannot wait to go through the legislature, or there is stalemate in the legislative body, that within the power that the executive has, they can issue an executive order. And we've seen examples of, and they're usually controversial, because the legislative branch will go into a tizzy over the executive stepping on their toes, because remember, statutes are supposed to be passed by the legislature, and the executive branch arguing, no, the reason for that is because it's a matter of urgent need, it's because the legislature isn't acting, where the executive branch is only acting within its authority for a short period of time, or whatever the case might be. But again, it's the law. Executive order becomes the law, just like a federal statute becomes a law. Regulations of administrative agencies. I think this should be highlighted. I think this should be starred. I think this page should be, really noted, because I think, one of the biggest sort of lack of understanding among non-lawyers or business students sometimes is not fully appreciating the impact administrative agencies have on businesses, right? So, you guys are going to go out and you're going to work in your various fields and so on. You're going to, if you're going to be auditors or accountants and helping, pharmaceutical industry, or looking at their books, or whether it's going to be manufacturing, whatever the area might be, or healthcare, whatever the field might be. One thing you have to understand is that those sectors of the economy are highly regulated, primarily by administrative agencies. And the reason for that is simple. First of all, what are administrative agencies? Administrative agencies are basically agencies that are created by the legislative branch and the executive branch. Right? So if you look at the Constitution, you find 3 branches of government. Right? But I jokingly say to you that there are actually 4 branches of government. It's official, but it might as well be, because administrative agencies might as well be the 4th branch of government, because they're that powerful, right? So, Securities and Exchange Commission, the Food and Drug Administration, the Department of Education, all of these, the Environmental Protection Agency, the Health and Human Services, Department of Labor, all of these huge governmental bodies that basically have the job of regulating a particular area, right? Where do they get their authority from? Well, they get their authority through the Constitution, even though if you read the Constitution, which I'm sure everyone will do tonight, right? What else are you going to do on a Saturday night but read the Constitution? But you're not going to find any mention of administrative agencies, because, the drafters of the Constitution didn't sort of think about that. It just sort of happened and evolved. But the legislative and executive branches of government have the ability to carry out their duties, and they've done that by establishing these various administrative agencies, not just at the federal level, but even at the state level. So these administrative agencies basically do what? Second bullet, they adopt rules and regulations to interpret statutes. That's huge. Think about it. What are statutes? Statutes are laws that Congress passes, right? They take those laws, if it's within their jurisdiction, within their authority, and they pass rules and regulations. For example, I gave you the example of the 33 and the Securities Act of 33, the Exchange Act of 1934. We're talking about laws that are now 90 years old. 90 years old, right? That's when Congress passed them. How do you keep them current? Well, you have rules and regulations under them, right? Who passes those rules and regulations? Securities and Exchange Commission, the SEC. So, administrative agencies, and what are they? They are as powerful as any other source of law. So what are businesses affected most by? Rules and regulations. Because if you read, the statute, the law that Congress passes, it's pretty vague, it's pretty broad. It doesn't have the specifics. It lays out the big picture. The specifics really come through a process of these agencies adopting rules and regulations. And that's why I say that it's so important, and we actually cover administrative law in a lot of detail, I think in business law too. There's a whole chapter on it, and we get to understand the process of adopting rules and regulations and how they actually decide disputes and so on. So just keep that in the back of your mind. I think this is a really important thing for you to understand and appreciate. And sort of rounding all of this off, judicial decisions, right? So we've talked about legislative bodies, we've talked about the Constitution, we've talked about executive orders, we didn't forget, but we didn't talk about court decisions, right? Those are also a source of law. We said a while ago they're precedent, right? So federal and state courts issue decisions. Those decisions state the rationale used by the court in reaching that decision. The court explains itself. Why did a case get decided the way it did, right? And that leads to, every class it seems to have some Latin introduced to it, right? Doctrine of stare decisis. Let the decision stand. Let the decision rule, which basically means, look, let past court decisions become precedent for guiding or deciding future cases. Remember common law, right? That's what cases in our legal system are supposed to do. They are supposed to set the legal principles that other courts will use to decide future cases that kind of relate to the same issues, which means what? Lower court have to follow precedent established by higher courts. And when we think about the highest court in the land, what is that? It's the Supreme Court of the United States. Every other court, we'll talk next chapter about federal and state courts, doesn't matter. That precedent applies to all various courts that look at those issues. So again, that's a whole other area that businesses, individuals obviously need to be mindful of. So let's talk about priority of the law. We've talked about all of these things. Well, we know the U.S. Constitution's treaties take precedence over all other laws. Federal statutes take precedence over federal regulations. You getting the terminology? Federal statutes take precedence, meaning trump, for lack of a better word, federal regulations. Well, now think back. What is a federal statute again? That is law passed by Congress. What is a regulation? A regulation is a rule of an administrative agency. If the rule of the administrative agency conflicts with the law, well, what's going to trump it? Congress is going to trump the administrative agency that it created. Now, I'm not saying that this happens a lot, but it could happen. We see lawsuits happening sometimes where someone will argue that the regulation adopted by an administrative agency was too overreaching in that it violates what the law allowed the agency to do in the first place, and it should be ruled unconstitutional. That's when you see those cases go to court. I'll give you a quick example. When the healthcare law was passed, 2 years later, it was heading right up to the Supreme Court based on this very thing. It can't be passed. It's unconstitutional. It violates the Common Clause. All those rules and regulations of the Health and Human Service cannot be constitutional. It came down to a 5-4 decision. It was close, of the whole law being tossed out. So I'm not saying that this is just sort of, it never happens. It happens, and it's, and when it does, it becomes very, very exciting. Just from a legal understanding sort of a thing. But yeah, you kind of have to look to see what are we challenging, what trumps what. Valid federal law takes precedence over conflicting state or local law. And we'll talk a lot about this. Here's federal law, and then here's state law. For example, just a quick example. At the federal level, we have the Environmental Protection Agency. And the Environmental Protection Agency will set standards for businesses. And will say that, in order for you to, work in this area, the contamination level has to be blah, 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 this percentage for it to be considered safe. Now, that business has so that's what they're going with, let's just make up a number, 0.5%. But this business has, operations all over the United States. And they happen to have, let's just say, operations in the state of Virginia, and the same operations in the state of Oregon, okay? Oregon has standards that go above the federal level. And they say, well, even though federal law says 0.5%, in the state of Oregon, your contamination levels have to be below 0.3%, okay? And in Virginia, the law is the same. The question here is that, wait a minute, is this an instance where the business has a right to argue that state standards are actually in conflict with federal law? Because didn't we say federal law takes precedence? So why is it that a business has to spend more money to reduce contamination levels down to 0.2% in Oregon when it can get away with 0.5% everywhere else in the country? Is that a conflict? The courts will say no. And the reason is federal law sets a minimum standard. States can always go beyond that, right? So if, for example, the state of Virginia said, no, forget 5.5%, you can have contamination levels up to 0.10%. That's in conflict. Why? Because 0.10 is more than 0.5, and federal law has already said you can't go above 0.5%. That's a conflict. But going below is being greener. And if a state decides that it may drive out business in its state by doing that, by regulating too much, but it has decided, that's why I picked Oregon, by being a little bit more greener, that's okay. That's not a conflict. That is just, it's not violating the minimum that the federal government is. So we'll talk more about these types of examples as we go on. And this slide is exactly the same thing. State constitution ranks as the highest state law of the land. State statutes take precedence over state regulations. Valid state law takes precedence over local laws. It's just a hierarchy system. That's all it is. So unless we've been living in a cave for the last, 30 years or so, we know that we live in a digital world. Really? We do. And the fact of the matter is, I like the way that the first bullet puts it, the electronic age arrived before new laws were written that were specific for the environment, and that's kind of true, right? We know that, from the, 80s onwards, when sort of business was sort of this novelty that computers were a novelty that a few businesses had, to fast forwarding ahead 30, 40 years when it's, it's a totally different world than anyone could have possibly imagined happening so very quickly. The thing is, so much is happening that is perhaps violation of intellectual property or, privacy laws or trade secrets or any of those other business issues that we could think about that, before Congress or courts could even decide these cases, this was happening. Right? So it is kind of true that, the laws that relate to the electronic age and to digital law are kind of just trying to keep pace with how fast technology is moving. But the fact of the matter is that you can apply existing law, even though we're kind of applying it to activities that relate to the digital age, if you will. So, for example, a dispute between two parties where one party's arguing cyber attack or whatever, or unfair competition, or someone stole their whatever by hacking into their computer. You may not have a specific law that says exactly that, but existing law that relates to, stealing trade secrets or dealing with intellectual property already speak to that. So it's not like the principles are not there. So courts have applied existing law as they, again, try to pass new federal statutes that regulate in specific the digital environment, So we start to see a lot of laws that are just relating just to the electronic age, but that's not to say that you need, every time that there's a new technology, that you need to adopt a new law. No, you have existing law that has, contract law principles, intellectual property principles can still speak to it, but yes, we'll see examples in the last decade, 2 decades, 3 decades that are specific to the digital age. And by the way, this is another example of flexibility of the law, because we all know that, laws written, let's just say, more than 50 years ago, couldn't possibly have contemplated the world that we actually live in today. I promised you Brown versus Board of Education. I said there was a slide on it, and indeed there is, right? So what is the Brown, by the way, when was Brown versus Board of Education decided? What decade? Can someone take an educated guess?
50s?
Absolutely. It was in 1954. And extra credit, what huge court decision did Brown versus Board of Education overrule? So this was a case from 1898, called Plessy versus Ferguson. People, come on, you knew this at one point in your life. And here was a case, Plessy versus Ferguson. So we go even further back to the history of our country, which again, we have to talk about these issues in order to intelligently understand it. But the history of our country has a lot of things to be proud of, and it has a lot of things that we needed to change because they were not things to be proud of. So think back to an era where slavery existed. Think back to what it took to abolish slavery, and think back to the amendments that needed to be adopted to guarantee equal protection under the law to all citizens. Okay, so the 14th Amendment gets adopted after the Civil War that basically says equal protection to all citizens, basically, right? And then someone brings a lawsuit which goes all the way up to the Supreme Court in Plessy versus Ferguson and says, well, wait a minute, because of my skin color, I am not allowed, and this was a case involving railway travel. I'm forced to ride this particular car on a train, whereas everyone else is riding that particular, and that is not, that violates the 14th Amendment, that is not equal protection under the law. And the Supreme Court of the United States in 1898 looks at that and says, aha, well, complaint noted. However, there is a way that accommodations can be given in a way that they can be separate but equal. So the court essentially decided that just because you separate people doesn't mean that you're not giving them equal protection under the law. And boy, that railway decision poured over into everything. It poured into education, it poured into how people were served at restaurants, where you could sit on the back of a, on and on. We know that this is the history, right? So, it marched on for half a century until finally, it reaches the Supreme Court. Same issue, is separate but equal and equal. Now, again, societal norms change, human thinking changes, all those schools of jurisprudential thought changes, and the court says, in a very well-written opinion, no, separate but equal is not equal integration. No more segregation. And we all know the sordid history of that and how that leads to the Civil Rights Act and so on and so forth. So yeah, that really was and by the way, 1954, and you almost never see that these days, it was a unanimous Supreme Court. So how many justices on the Supreme Court? 9. All 9 agreeing that separate but equal. And by the way, it's a very different era. People could have had very strong opinions one way or the other. And yet, when they looked at the Constitution, they could not find a way to justify how separate could possibly be. And the reason that this case is so huge is because it shows how society changed and how it sort of, led into the modern era of the Civil Rights Act, but also how you could have precedent totally overturned. Yes, it took 50 plus years, but it can change. And it did change. And we've seen, there are other examples of it, but this was probably the biggest example of how, again, the evolution of the law, if you will. And I'm going to spend a whole lot of time about critical legal thinking, just to say, yes, I mean, the law, I kind of said this in my introduction, the law is not black or white. I mean, it involves looking at, all kinds of information and then applying that information, those rules, those regulations, whatever it is, to very complex legal issues. I mean, if this was easy, we wouldn't be going through a lot of these stages, and there are many, many different ways of thinking about it. Anyone know what the Socratic method is? Believe me, you wouldn't want me to do this to you, but this is how law students, even today, get taught. Like, you sit around, you have no idea you're going to be called on, you're usually like hiding underneath, looking down, and that's the surest way of being picked on, by the way. And basically, you just engage in a question and answer way. It's sort of what I started to do to someone when we were doing the Palm case, and I said, I'm going to play the devil's advocate, and I'm going to say, well, why? Why? That's sort of the Socratic method, which is like you challenge those views, and you say, well, why? It's not like I'm picking on you. I'm sort of getting you to really defend and think critically and so on, and have a debate between two people and so on. So that's one way of critical legal thinking. We sort of will be a little bit more softer than that, if you will. All right, real quickly, there was one other case in this chapter, and this was the Voting Rights Act case. Huge case decided only 2 years ago. Only 2 years ago. This is why I like the new version of the textbook, because we have a lot of recent cases. Did anyone read this case? So what this case really quickly involved was the Voting Rights Act. So again, bear with me on the history, if you will. So we went through Brown versus Board of Ed and so on, and we have the Civil Rights Act sort of happen, and then Congress passes the Voting Rights Act, and the Voting Rights Act basically said, look, people should not, all citizens have the right to vote, and there shouldn't be a way that states that can kind of have a lot of say in how voting works within their state borders, that they somehow figure out a clever way of keeping people out of participating. Because at the time you were finding things like, well, you have to own property to be able to vote, well, you have to pass a literacy test to be able to vote, or if you don't, all ways in which ultimately sort of was discrimination to keep people from being able to vote. So when Congress passed the Voting Rights Act, they put in a provision in there that basically singled out a few states that had a history of this and said, look, we're watching you, says the federal government. If you're going to pass any of these kind of requirements in order to vote, you got to clear it with us, okay? And for the last 50 years, basically, Congress just kept renewing that authority. So I'm going to name the states, but they're in the southern region of the country, let's just leave it at that. That they just had to go, it was embarrassing, they had to go to the federal government and say, can we do this, can we do this? And the federal government would look at it and say, no, yes, whatever, because it was this notion of, you've done wrong in the past, we don't trust you, we want to oversee it. And by the way, it went from 5 or 6 states to a few more. So then finally, in 2013, this case winds up in the Supreme Court because these states are now arguing, we don't need this anymore. We don't need the federal clearance anymore. And they argued that, look, in our states, for the last however many years, we have as many, if not more, whites versus non-whites participating. So you can't say we need this anymore. The numbers speak for themselves, and this notion that you need federal clearance should be thrown out. And people were shocked because the Supreme Court agreed. Congress had passed a 25-year sort of extension on it. The Supreme Court, again, branches of government says you don't need this anymore. And to this day, and again, I'm not taking the political positions one way or the other, I'm just informing you that there are two sides to the story. There's a side that feels that this decision, by the way, was a very close decision, right? That this will happen again. That the only reason that things were working properly was because of this threat of federal clearance. If you take that away, you're going to wind up with other artful way of local officials trying to keep the vote down in certain parts and so on, and influencing elections and so on. But be that as it may, Supreme Court law of the land no longer requires federal clearance under the voting rights. So that was a huge, huge decision.